take a specific topic in. Oh, sorry. An issue? Do you see the slide?
Here we go. Yeah.
Okay. Yes, I've chosen a specific topic because ESG is a very wide topic. So I decided to actually focus on mis-selling of ESG funds. But I wanted first to give you an overview of ESG. In the recent years, there has been a mounting public interest for ESG products. PwC has forecast that more than half of the funds in 2025 will be ESG. And so investment firms have been increasingly focusing on establishing ESG funds. So on the market, there are numerous ESG funds or labeled ESG, and firms have been expanding their offering to investors. The main issue in Switzerland currently is that there is a lack of clarity in the absence of a definition of green, sustainable, and ESG terms that are included in the name of the product or in the description of the product. That may lead some companies to actually exaggerate the ESG aspect of the funds, and might constitute a mis-selling or misrepresentation towards investors that actually had an interest for investing in products that will have a beneficial impact for the planet. That is called actually greenwashing. Greenwashing might actually trigger a reputational risk for companies. It can be bad publicity. And in newspapers, for instance, you had Credit Suisse that was accused of not doing too much for the climate change, despite the fact they are claiming and advertising that they invest massively in ESG products, and they have specific policies to try to tackle the climate change. It's also a cross-border risk for Swiss banks because the financial watchdog reminded banks that actually they also have to abide by foreign laws and foreign regulations, and that ESG greenwashing could be considered as a breach of regulatory duties. So we may see regulatory actions against financial firms in Switzerland. And this could also trigger litigation brought by investors against Swiss banks or charities and associations. I think ESG actually will have a huge impact on the financial intermediaries, but also law and lawyers. It will be, I think, in the next years, more and more included in our practice, be it from a regulatory perspective, a civil perspective, or even a criminal perspective. Because in Switzerland, for instance, we implemented a new obligation for companies, large companies, multinationals, banks, and insurance for the time being, that have a duty to disclose the impact on global climate warming, also their impact on the diversity or the gender pay gap or child labor, etc., etc. So they have now a duty to report. And other companies, all companies even have a duty to conduct due diligence in some specific areas like child labor. So they have to have a whole internal process now, policy, a risk management process, and all that actually is must be included in the governance of the company. And so a lot of work in perspective for lawyers advising IT companies and corporations in these aspects. We'll see also, I think, increase of litigation against the compliance officer, because it will be part not only of the risk management of the company, but also the compliance of the company. And in Switzerland, they enacted provisions providing fines in case of breach of the obligation reports, disclosure reports, or due diligence. So we would see, I think, in the next 10 years, even individuals working for companies prosecuted for breach of ESG regulations. So about funds, the FINMA, the Swiss Financial Markets Supervisory Authority, conducted last year on-site inspections on funds and asset management companies. And then they analyzed the ESG product that was selling and how the companies were functioning. And they issued in November 2021 guidelines on preventing and combating greenwashing with a focus on the risk of misleading clients. The FINMA actually chosen to investigate in the fund industry because for the time being, there is no general law in Switzerland allowing the FINMA to act against service firms providing other products than funds. In Switzerland, like in other countries, we have a specific regulation for funds, and it allowed the FINMA on the basis of very all-encompassing provisions to actually investigate and reprimand management company if they are breaching the general provisions that are encompassed in the Swiss Collective Investment Scheme Act. For instance, the name of fund must not be confusing or misleading. The fund documents also have must provide a minimum content, and the persons in charge of managing the collective investment scheme or holding the assets and the custodian bank have duties, general duties of loyalty, due diligence, and disclosure obligations. So on that basis, the FINMA can act against collective investment schemes and fund management companies to check exactly what they are doing and if they are not committing greenwashing. I took an example I have students at Fribourg University, and I gave her the topic of greenwashing, and I found, for instance, this prospectus, and you can see that it's a good example of greenwashing, I think, in my opinion. At least under Swiss law, it would be greenwashing for the time being. You have the name ESG screened UCITS in the name of the fund, and it's indicated that in the key benefits that this fund is screening out exposure to controversial weapons, nuclear weapons, tobacco, thermal, oil, etc., etc. But when you have a look closer to the asset allocation of this fund, you can see like actually they invest massively in Apple, Microsoft, Amazon, Tesla, okay, Meta, Facebook, etc., etc. But from an investor perspective, I think with people interested in investing in companies that can have a really beneficial impact on climate change or the fight against inequalities, these companies are, in a certain way, to a certain extent, controversial. Like Apple I was in London a few weeks ago and I saw a protest in front of an Apple store because of the forced work of Uyghur in China. And also Microsoft, we have all the issues of the IT material that is not lasting more than a few years, and we need to replace cables, etc., etc. It's not like what could be expected by an investor that would wish to have invest in solar panel companies or wind turbine companies. And that would be, for instance, considered as greenwashing by the FIMA under a list of criteria that has been determined in guidelines issued by FIMA last year. So they gave some examples of what would constitute greenwashing. So I can present a few. There is the no implementation of a sustainable investment strategy. So the fund will claim like they have a specific sustainable investment strategy, but in fact, they don't implement it. The investment policy may not be in line with sustainability approach pursued. Can be, for instance, the best-in-class approach. Like the fund is claiming that they will try to find the best companies in their class, providing real change in ESG, but in fact, they are not doing that. It can also be the no implementation of the information about the sustainability approach decided in the investment strategy and policy. Or you can have the use of terms like zero carbon or no impact, which have not really meaning, and there is no real definition, just marketing, and the aim is to, in a way, deceive the investors. The FINMA is not only focusing on the product itself and the pre-contractual information, but also the organization of the fund. And it looked at how the fund is managed and organized to ensure that it's tracked, that it's still ESG compliant. So they have a few now conditions that have been imposed to fund management companies in Switzerland. They need actually to fully integrate sustainability in the investment decision-making process. They have to hire people with specialized expertise and knowledge in the field of sustainability. And they need to assess and monitor that they actually use reliable data, external data. That you can see on the market, like some companies are starting to advertise that they can provide the data, because it's a huge issue for fund companies. They need actually to be able to rely on accurate and robust data in order to evaluate if the companies in which they are investing are really ESG compliant. But the next steps in Switzerland are to obtain a report laying down recommendations to actually establish a meaningful climate compatibility indicator. Because without the indicator, it would be impossible to compare products. It's a bit like the labels used on the fridge, A, B, C, D. They want the idea is to have the same for financial products in Switzerland. And they want also actually to have concrete proposals to prevent greenwashing, not only in the fund industry, but in general in financial products in Switzerland, to have comparable standards. So the fight now is actually to establish standards to be able to compare the products and to compare the companies. So we see, I think, an increase of regulatory compliance that will have to be ensured by the government. we see more intervention of the government in this respect. I think also we have to provide additional tools to deceived investors to file civil claims for damages, because the main issue now is the definition of the damage. Because in the example I gave you, if you have a look at the performance of this fund, we can see that it's increased by 50% within a few years. So even if the investor is deceived, yeah, well, there was a contractual breach, but there is no damage, no monetary damage. And for the future, I think we have to rethink what is a damage and how we can evaluate it when actually the value of an individual has been deceived, and that there is no real monetary damage, but there is another damage, a damage to the environment, to the suffering of children or humans in general. And maybe a way Switzerland would have to allow punitive damages, like in the US, which is now not even recognized or even contrary to public order in Switzerland, might be a way, or to actually include such damages in the moral harm that could be claimed against the corporation. And also, last thing I wanted to share with you, I think we see ESG is not really new. It's part of ESG has already been at the front line for many years, because the fight against corruption actually is ESG, the fight against money laundering is ESG, the fight against human trafficking is ESG. And I think we might see in the 10 years a change of the criminal corporate liability, because under Swiss law now, corporation can be criminally sentenced for money laundering, human trafficking, financing of terrorism. But I think it would be so important to fight climate change and social inequality in the next decades, that we might see a change of the law, and we might see that the criminal corporate liability will be extended to all ESG matters. Thank you.
Very much, Nicolas. Questions? I have one. Having showed us what the framework for ESG-related compliance for funds is in Switzerland, would you say that in Switzerland are the front runners in terms of this compliance, or are we behind, or what's the on an international base, what's the situation?
It's a very good question. It's difficult to know exactly, because well, in Switzerland we have a different system than the EU, for instance. We don't have very detailed regulations. Like if you check MiFID and the Swiss Financial Market Act, the Swiss Financial Market Act is like 20 pages, and MiFID it's hundreds of pages. So we try to implement law at a very general level, how I explain now, and the FINMA and the Swiss government are claiming that to be at the front line of sustainability, and the aim is to have the Swiss banking industry as the leader in the sustainability world. I think, well, it's still evolving. Was almost at the same level that the EU, but the EU is actually, I think, enacting more detailed laws that will be, in a way, integrated in the more general requirements imposed by the Switzerland.
Thank you, Nicolas. Other questions?
Maybe I didn't follow carefully, but all the investment funds must have sustainability policy. It's only for the people who adapt their projects.
No, it's not a requirement to be sustainable for funds. But the funds claiming being sustainable, they really need to be sustainable. Because you need to distinguish funds and companies, you know, and now some companies, large companies, banks and insurance, in a way they need to analyze the impact on sustainability and the risk they actually incurred because of ESG. So it's really different.
Daniel?
Yeah, so along the lines of what you're saying about companies, in the US, there's a nonprofit now that has their own definition of what is an ESG company. And you can pay them a fee and they'll designate you as something called a B corporation, which is essentially a label that is to justify that you are legitimately an ESG company and they have their own criteria. It's a private nonprofit, but it does have a certain level of weight to it in terms of, you know, proof that you're a legitimate ESG company. I'm wondering if there's any type of organization like that in Europe that would, separate and apart from a governmental agency, have a private agency that kind of puts the seal of approval on the ESG side.
Well, to my knowledge, in Switzerland, there is no such company providing this label. Well, I don't even think it would be authorized by law to have this label. The issue I see, you know, it's in competition law. You should not be disloyal compared to your competitor, and that if you are not really ESG and you claim to be ESG, or even just claiming being ESG compared to your competitor, can disturb competition. And I think it will be more the competition authorities checking this type of matter.
Thank you very much, Nicolas.
Thank you.
Bruno, it's wonderful to have you on the panel as well. You're partner of here at DSM Luxembourg. You work for different law firms in Luxembourg, and you are, of course, a member of the Luxembourg Bar. And you're an expert in commercial and business law, and especially I've seen in data protection. So you also work for Luxembourg's National Commission for Data Protection. And you're very involved in the data-driven industry, I would say. I've just seen that you just recently gave a presentation on the dematerialization of assets with the wonderful title, "You Token to Me." I like that. And you also know how EU law works, because data protection is mainly EU law driven. So and you also know how corporates work from your commercial and law background. So you're a wonderful presenter for the topic corporate governance in connection with ESG in the EU.
First, I want to share my pleasure to be here, and thank you for being here and attending in physical this meeting. Thank you very much. So the point about ESG is that, as you mentioned, it's something that is quite old, in fact. Back in 1682, we already found traces of first thinking about ESG, corporate governance. At the beginning of the United States, so we find traces in Philadelphia, because the Quakers who were established there decided not to invest in certain type of industry for religion purposes. So this was the beginning of ESG. So no investment in weapon company, no investment in alcohol companies, this type of things. So the ESG involvement, thinking is very old. Then in the fund industry, which was created also in the States, we can find politics. So Daniel, you were telling about who could control and check this. We will have a word on this. But basically, as you know, Luxembourg is a large fund industry place, and the fund have to publish prospectus in which they will indicate which type of investment they will do and so on. And this type of investment will be controlled by the external auditor. So initially it was only on the finance. Now there is also audit on IT tools. And in the coming years, there will be also audit on the ESG aspects. Because as you exactly described, this could be wrong information given to the investors. So to me, who will control this in the coming years? That will be the external auditors. But this is, I'm very pleased to talk about this today because this is something that we can see in the M&A world, notably in the due diligence. This became a huge topic because when a fund decides to invest, and I had the case last year in a tech company, they want the tech company to confirm that its ability to cope with the ESG rules, because it's a duty for their investor in the fund to be able to demonstrate that their investment is compliant with what they mentioned in the prospectus. So in the process of the due diligence, it was mandatory to check whether the tech company was indeed able to cope with those criteria. And the point is that the criteria are very ongoing, not fixed yet. So this is a moving target for the time being. Back on the corporate governance, the first written principle were drafted in South Africa, in the UK, in France, beginning of the 90s. So this is not that old. Then OCDE principle again in the 90s. And now in certain type of industry, there are mandatory regulations to be approved by the companies. For instance, I gave one in Luxembourg. All listed company have to establish corporate governance principle, and there is a list of 10 points that should be approved, and so you have to get this document at the level of the board. So corporate governance, what does it mean? It's always a balance between on one side the entrepreneurship and the other side. So what do we want? What type of industry do we want to invest in? And on the other side, the performance and risk control. So this is where we are. It talks about integrity, accountability, risk management, transparency, and CRS ESG. So the main topic about corporate governance will cover diversity, security, sustainability. The diversity could be, there are many other examples, but could be gender equality, status of the people, expertise. In the governance, you will have to demonstrate that the people you appointed are capable and have the knowledge to do what they are supposed to do. For the security, it's the information that you will give to your investors, to the public, in terms of finance. But it's also whistleblower. You will have to organize protection of those people in case they find something wrong in the company. This is quite recent. This is something we were not talking about 10 years before. It's also about data protection. And data protection is also something to be checked nowadays in the due diligence. Back in 2018, Marriott, the hotel group, was purchased, and 1 year after, they had a huge sentence for data protection breach, more than 100 million pounds. So in the process of the due diligence, maybe it had been covered or not, I don't know, but this was with the gift, the package. So you have this fine to pay. So it has not been paid because of various recourse. But still, this is a point in the due diligence. And there is also COVID-19, digitalization, what happened, increase of prices. So this was more the topic we discussed this morning that you demonstrated. What what happens in case of changing the market. So this is also something to be covered in the governance of the company. And sustainability. So climate change, green bonds, European legislation. The idea behind this is to be able first to increase the transparency over the investors. Second, to trace the funding. And there is in EU a policy to favorize, to organize a tracing of the funding and to orient the funding with this type of investment for fighting against the climate change and so on. So what are the tools regularly used and for some of them mandatory? Policy member for the board. So you will have to explain in this policy who are appointed, for which reason, which are the criteria, remuneration, gender equality, this type of things. Compensation policy, so what do you pay to your board member? Do you have a specific rules of ratio between the lowest and the highest salaries in the company, this type of things. Anti-corruption policy. That was one of the key points of the development of corporate governance. The initial policy were only focused on corruption, fight against corruption. Back in the 90s, the corruption was only a problem if it was done on your own territory. For most of the countries, you were allowed to corrupt people abroad, but not in your own country. It's not anymore the case. So it's very important to have this type of policy, especially for international companies dealing with various jurisdictions, because the term, the qualification of a corruption is very different from a zone to another. So you have to be extremely aware when you're an international company on this. Of course, there is IML, fight against terrorism policy. This became mandatory, but this was not the case 30 years before. Whistleblower protection. In some jurisdictions, it's mandatory to have this type of protection for your employees, but not everyone. So it can be based, this type of policy can be based on a decision of the company itself and only. Then you have the information security policy, cybersec, data protection. This is also something that is important. And then the policy on environment, social responsibility, treatment of employees, respect for human rights, anti-corruption, and diversity. So these are the tools that companies have to think about, and as the case may be, to implement at the level and to approve at the level of the board. Now, ESG and legal evolution. We moved from something that was soft law on a decision by the company to something that more and more and more aspects become hard law. And these are only examples, but back in 2006, it was the obligation to have external auditor that was increased over more companies than before. So this is already something about corporate governance, but from something that was not mandatory by law, it became mandatory by law. The same for the finance, for the annual accounts. Consolidated accounts, all those regulations now became mandatory. But before, there was no legal obligation to have consolidated accounts, for instance. So the way the accounts are presented, generally accepted principles, the IFRS, all this now is extremely structured, but it is corporate governance. Then the obligation about information on beneficial owner, which is something much more recent than the others. For instance, in Luxembourg, there is, because it's a EU law, so there is this obligation to have the beneficial owner register, but each country has an option to decide who will get access to this. And in Luxembourg, they took the broadest possibility, which means everyone. So you just have to connect on the internet and you can get the name of the beneficial owner of any Luxembourg company. So on one side, you have the GDPR and data protection rules, which say things should be protected, you cannot publish anything and you cannot keep the data. And on the other side, you have this type of regulation where it says it will be fully transparent. with many, I think in Luxembourg today, there are more than 2,000 cases against the register because there is an option to ask for or to apply for a limitation of the access, but it has been refused 100% except for underage beneficial owner. But in all the other cases, it has been rejected. But it's corporate governance as well. Labor law, gender equality, fight against discrimination. Now it's in the labor code in Luxembourg. Before it was not. It was just on a voluntary basis for the companies. Now, ESG, environment, social governance. So we have a couple of regulation, directive and regulation for non-EU people amongst us. The difference between a directive and a regulation is the directive must be implemented in each country by a separate law. So you have the general rules, and then there is need of a separate law in each EU country, whereas a regulatory is directly, automatically enforced. So the first one is the first one, the 2014-95 directive, was about the obligation to publish information on environmental issues, social issues, treatment of employee, respect of human rights, fight against corruption, diversity in the boards of directors. But it was limited to listed company, bank, insurance company, and public interest company. So quite narrow. But still, this was a beginning. There is a couple of evolutions that are proposed. So I mentioned CSRD, Corporate Sustainability Reporting Directive, which is still a draft project, not in force, but in a good way. And the idea is to extend those obligations to more companies and to be more precise in what should be mentioned by those corporations, those companies. And there was a very recent proposal about this that was published. Then the main point, the two main regulations. First one is 2019-2088, sustainability-related disclosure in the financial services sector. So again, it's narrow, it's limited to certain type of industry, but you have to, in the process and the publication of documents that are made public by the companies, there is an obligation to publish information on the sustainability risks. And this is, again, the way, the idea to increase the transparency towards the investors. There is also obligation of transparency over negative sustainability impact. So companies on which you will invest, oil companies, for instance. Remuneration policies. Sorry? From Russia. But it's now it became blacklisted. This is another story. And transparency on, of course, environment, social and governance, financial product. So it applies to companies outside the financial sector, but with more than 500 employees, which means already quite large companies, at least for Luxembourg, from a Luxembourg perspective, and also companies in the financial sector. And this is the last one. This is the most recent. This is the hot topic of the moment. It's called the taxonomy regulation. So this is a regulation which means it's already in force. The idea of this regulation is to define criteria to classify sustainability economic activities. So you have in this regulation a list of what is sustainable, what is not sustainable, and what are the consequences. The point is that it's extremely technical and not very clear. So there is additional documents that are being drafted right now. They are not completely finalized, but they should be in the coming 2 years. So definition of environmental and technical criteria for various activities. And then the company will have to share the information on the revenue expenses that are taxonomy compliant. And ultimately, the idea is to be able for the financial actors to calculate the share of the portfolio which is compliant, which is green. So the regular, I was mentioning the difficulty about the technical aspect. In the file I had to deal with last year, so it was a tech company, and no one was really able to fix precise criteria of what you should comply with to be green. But the fund which was invested in this company was a green fund. And so for them, it was extremely important to stay and to be able to demonstrate that the company will cope with those criteria, but the criteria were not known. So there was a list of criteria, there was an agreed principle to comply and to adapt depending on what would be the outcome of this legislation, and the investment was done. But this is one of the main difficulties that we will face in the coming years, and that could come to litigation case, of course. So the evolution of this regulation should be in full force in 2024. And I'm done.
Thank you very much, Lino. We are open for questions. So I would have one. Let's imagine there's a tech company coming to you, and they're grown, and now they are probably looking for new investments, also from funds. They say, okay, no, we have to be really ESG compliant. What would you say would be the biggest obstacles for this company?
The first thing is that under this regulation, you have three levels of green. So you can be green, you can be mid-green, or you can be high green. And so the first thing would be to check what is the level you want to opt for. So basically, you will have to go back to the prospectus of the fund to check what is written, what they promised to their investors, and then you will have to see in which of those three boxes you have to enter into. And then the point will be technically, what does it mean? In terms of use of energy, in terms of recycling, in terms of positive impact over the environment. So there will have to be a deep thinking about this. But when you are a tech company, you need a lot of energy, for instance. So this is already an obstacle because you will have to use energy. Will it be electricity? Will it be gas? Will it be oil? So this is something to think about. And depending on the answer, you will enter or not into the boxes. But the key point is indeed to check what is written in the policy of the fund that will invest in your company.
Thank you very much. Other questions? Okay. Thank you very much for that.
Thank you.
Okay, so now I'm happy to introduce you Riccardo Caggiola. He's an Italian lawyer from the law firm Caggiola & Associates, and his expertise areas are M&A, private equity, real estate, and tax, and more specifically transfer pricing, tax aspects of M&A, international tax planning, inheritance and estate planning, and real estate transactions.
Thank you very much. I'm just trying to.
Okay. It's good. Yeah. Okay. Perfect.
Okay, well, Daniel and Renaud touched upon several very important aspects concerning ESG. Renaud talked about soft law, we touched upon national law in Switzerland. Renaud talked about governance. So now it's my turn to talk about the ENS of the ESG. And I'm very glad that Renaud concluded his presentation talking about taxonomy, because I'm going to talk about the due diligence. So taxonomy is basically the classification of ESG, of what constitutes ESG, mostly environmental, also classification for environment and another for human rights and social governance behavior, good practices. But the European Commission has recently adopted, last February, statutory regulation proposal, which gives us a tool beyond the classification to assess the compliance not only of companies, but of all companies throughout the distribution chain. So the aim is to foster sustainable and responsible corporate behavior throughout the global value chains, which is something more than talk about value chains is something more than just distribution chains, because it triggers all contractual relationships. And the rationale is that companies have a key role in building sustainable economies, and they will be required to identify and prevent or mitigate adverse impact of their activities on one side on human rights, like for example, child labor, exploitation of workers, and on the other side on the environment, for example, pollution or biodiversity loss. We made some example before. So for businesses, these new rules will bring legal certainty and a level playing field. For consumers and investors, more transparency. The rules, therefore, are meant to advance the green transition and protect human rights in and outside Europe. Daniel pointed out that some companies have adopted their own measures of soft law, and some member states have their own national rules about due diligence. However, the Commission has found that there is a need for larger improvement, which is difficult to achieve just with voluntary action. So the proposal will apply to EU and non-EU companies. Basically, the regulation divides companies in three groups, actually. We have EU companies and we have non-EU companies. As far as EU companies are concerned, Group 1, this will apply to all EU limited companies of a substantial size with more than 500 employees and a net turnover of more than 150 million euros. While Group 2 will be all other limited liability companies operating high impact sectors, for example, textiles, agriculture, mining, which do not meet Group 1 threshold, but have more than 250 employees and a net turnover of over 40 million euros worldwide. And for this rule, for these latter companies, rules will apply 2 years later than those of Group 1. And then we have the non-EU companies that are active in the EU with the turnover threshold aligned with Group 1 and 2 generated in the EU, and the regulation will apply to these companies as well. That means that small and medium-sized SMEs companies are not directly within the scope of this proposal, although they may be affected as well as when we say down the value chain. So companies will need to take appropriate measures, so-called obligation of means, in light of the severity, likelihood of different impacts, the measures available to the company in specific circumstances, and the need to set priorities. And national authorities will be responsible to impose sanctions and fines in case of non-compliance. Victims, including non-EU residents, that's a new thing, will have the opportunity to take legal action for damages that could have been avoided with appropriate due diligence measures. For example, if a European company down the value chain creates a risk that turns into a damage for a person working in a company outside the EU, then this company, which was not previously entitled to sue in the country where the European company is based, now he or she will be. So before it was he or she was just able to sue in his or her own country. So Group 1 companies shall also have a plan to ensure their business strategy is compatible with limited global warming to 1.5 centigrade degrees, in line with the Paris Agreement. So we don't have just human rights issues, but we have also protection of the environment and also action against global warming. So why is the Commission presenting this initiative? As we said, a sustainable economy is a key political priority for the EU. Companies play an important role in sustainable economies and societies, and they need support to a clear regulatory environment. That's what the Commission thinks. Why is voluntary action by companies not sufficient to address human rights and environmental concerns? Well, because commitments of corporate sustainability tools help definitely to tackle sustainability problems. However, when they take voluntary action, they focus on the first link in the supply chain, while human rights and environmental harm occurs more often further down in the value chain, and besides, progress, of course, is slow and uneven. So this is why the Commission thought it was time to adopt a proposal of due diligence like this one. So in practice, what will companies be required to do? Well, we said the proposal sets out the due diligence duty to identify, to prevent, to bring to an end, or mitigate, and account for adverse human rights and environmental impacts in the company's own operation, and also its subsidiaries and throughout the value chains. And that builds up on the UN's guiding principle on business and human rights and the OECD guidance for multinational enterprise and responsible business conduct. So it's nothing new. And it's perfectly in line with international recognized human rights and labor standards. So in practice, companies will be required to integrate due diligence into their policy, to identify adverse human rights and environmental impacts, to prevent and mitigate potential impacts, bring to an end, minimize actual impacts, establish, maintain a complaint procedure, monitor the effectiveness of the due diligence policies and measures, and publicly communicate on due diligence. Companies shall take appropriate measures, for example, regarding workers' access to adequate food or clothing or water, sanitation in the workplace. And this will be all monitored. So what shall directors do and how will their duties be enforced? Directors will be on the first prong because they shall set up and oversee implementation of the due diligence processes and integrate it into corporate strategy. They must take into account the human rights, climate, and environmental consequences of their decision and the likely consequences of any decision for the company in the long term. And where they enjoy variable remuneration, they will be incentivized, that's in the directive, to contribute to fight climate change by reference to the corporate plan, taking into account these factors mentioned. So will all companies be affected by these rules? No, we said they will only apply to large limited companies with substantial economic strength, whether EU or non-EU, provided they generate turnover threshold within the European Union. And SMEs, we said, do not fall under the scope. However, we said that they might be indirectly affected by the new rules as a result of large companies and actions across the value chains. So what happens if companies do not comply? Member states will supervise compliance with due diligence obligation and will be able to impose fines to companies or issue order requiring companies to comply. And here, the most important news, as we said, is enabling victims to get damages to compensation. So those affected will have the opportunity to hold companies to account, and this means we'll have the possibility to bring a similar liability claim before the competent national court within the EU. So how will enforcement be ensured? Well, member companies will be required to adapt the rules and similar liability to cover cases where damages result from failure to adopt or to comply with due diligence obligations. And what will be the benefits for citizens? They will be more aware of the impact of products they are buying and services they use. Main benefits will be more transparency and reliability on how products are made and services delivered. More protection of human rights and sustainable business models shall protect against human rights abuses, and a healthier environment, of course, especially from a longer term corporate commitment to the environment. This is for citizens, but what are the main benefits for companies? Well, there will be common rules of corporate sustainability due diligence, and the main benefits
Then will be those of one side to prevent legal fragmentation, as we said, because some countries have their own national rules, but this brings legal uncertainty for companies across the EU and probably more cost of receiving proper advice within 27 nations. Meeting consumers' expectations, consumers are drawn increasingly to sustainable products, for example, without using harmful substances. Meeting investor expectation, we will talk about that, and then we'll touch upon as well. Investors prompt to respond transparency requirements, so without mandatory actions, investors and consumers would miss consistent benchmarks, for example, to be assured about the value chain standards. This is the tool again to put taxonomy into action. Reinforcing risk management. Companies with a clear view of their operations and supply chain will be able to detect problems, risk upfront, including reputational risk. Generating economic benefits. A EU Commission research shows that companies incorporating sustainability factors into their policies generate higher returns and also increasing resilience. That also has been found that companies with integrated social, environmental, health considerations into their strategy face, for example, the COVID crisis better and saw a minor drop in stock prices during pandemic than those who were not. There will be costs. Of course, there will be costs for companies, but in the long term, this will be offset by benefits. To comply with the new rules, company may probably incur costs related to establishing and operating due diligence procedures. And in addition, they may also incur a transition cost from investment needed to change their operation and value chains to address adverse impact. And finally, I just want to mention that the impact of the new rules on developing countries. The new rules will bring benefits for developing countries, including a better protection of human rights and environment, better adoption of international standards, and better access to remedies, as we said, for victims of harmful corporate practices. Thank you.
Any questions? Okay.
I'm sorry, question, but I have a fairly delicate question because we had a case in Belgium. There was a decision condemning the state to respect the climate change rules, and then the judge refused the specific performance. He said, no, it's up to the state to arrange. My question, you say that action with civil liability is possible, but can the action, can the judge force the directors to respect rules? Is the judge only entitled to grant damages, or is he entitled to say you have to respect the rule with judicial penalties? Do you understand the question?
Yes, well, I think, as we said, as I said, there will be need to adapt national rules to the new directive on one side, so that that will probably differentiate from country to country. But on the other hand, the directive calls also to incentivize directors to comply, to oversee these new rules. For example, their variable remuneration, that's a provision. The directive shall be tailored to their ability to oversee and grant some minimum due diligence standards and to meet targets. So there are probably two ways to achieve the same result.
Any other question?
Stefano, please.
Yeah. Carlo, I wanted to pose the question already at the end of Renault presentation, but now I can't avoid to pose this question. We have seen that there is a long list of requests and doubts on these orders, but according to me, the end should be more interesting. in managing all this should be OECD. That I saw that you mentioned in your presentation. Are you in agreement with that? And there are other entities that should play an important role in the development of this ESG
Yeah,
activity.
well, actually, this is, I mean, OECD sets standards, standards that can be adopted, that are agreed upon by countries. Here we're talking about a supranational statutory regulation, which has been proposed by the European Commission. So definitely, as we said, this new regulation has been conceived taking into account the OECD guidelines in terms of best practices and responsible business company for multinational enterprises. And as well, making a reference as far as human rights are concerned to the UN guiding principle of business and human rights set forth by the Professor Rube some years ago. But again, this is a. I don't think. Yeah, probably in the long term, the OECD might have a voice on this as well. That's a good point actually. The OECD role could be to expand this best practice, let's say, which is now being limited to the European Union, to extend it to other countries to adhere, to participate, or set up supranational standard. I'm not by the answer to the question.
Maybe I can add a word. When it comes to corporate governance, OECD rules are outdated, 30 years old, so it has to be improved. But we saw that, for instance, in the fight against money laundering, OECD was in front. So probably that will be the same way. But this is nothing unless the state, at the level of the EU or at the level of each state, decide to implement mandatory rules. This is why, from soft law, we have to move with hard law, in my opinion, because otherwise, principles, as I explained in my presentation, we think about principles since 3 centuries. What's the result? It has to come into force in the various legislations, otherwise it won't work. And we are facing, I mean, huge problems in the coming 20 years in terms of climate, in terms of war, in terms of future for our kids. So again, in my opinion, I'm much more radical, but we definitely have to implement things in the law and to force everyone to consider those points, and not only to think about the return on investment at short term.
Just to add, I totally agree with Renaud. I think bringing this to the OECD level, if we're talking about human rights, will be more difficult, because human rights goes for not every country. I mean, human rights is defined by the United States, but clearly there are some countries who are less eager to implement human rights than others. So, but in the long term, this will be matter of discussion.
Dan.
The last question.
Yeah, so I've heard a lot and learned a lot, thank you, about all the environmental regulations that sound like are in the pipeline or already on the books and how they're being implemented. I haven't heard as much about the governance guidelines, if any. Like, for example, I've seen, at least in the state of California, efforts by the legislature to mandate on the board of directors level certain participation by females on the board of directors or by other underserved representation, one of which was recently struck down like 4 days ago by the courts, but those efforts have been tried. And I'm curious to know if there's any similar efforts on the governance side like there is on the environmental side.
There is, but not at the EU level. As I know, for example, in Italy, it is mandatory for listed company to have in the board a sufficient number of female members. At least there must be gender, a proportion in gender for the board of directors, but that's just for listed company.
Just one question, maybe following on to what Denis asked about remedies, and I gather that this directive is targeting kind of private enforcement, civil claims. But who has standing?
Anyone who has been damaged, whether he's based or not in the EU, that's the new thing.
But that's
Anyone.
okay.
But for example, the point is that in developing countries, maybe you are entitled, maybe it's more difficult to have access to justice.
Mhm.
And even if you have access to justice, then those who profit from the activity are not based there. So the new thing is that you will be able, someone will be able to get upstream to the corporate chain, the value chain, and get remedy in a place where he can have a real remedy.
If I may intervene, you see the new European regulation, the judge is competent when the place of the damage. This it can be that the damage occurred in Peru, for instance. Peru is not a good for Europe, but if it is in Portugal, even the companies in Germany, because that's something possible. And there are a lot of cases now concerning this kind of damage occurred in Nigeria, and the court in England considered it competent because it extends to the mother country. But that's a very complex topic, but that's.
And we're talking about sort of a global type of damage, you know, and not whether effluents from Germany landed in France. You know,
in the US,
jurisdiction is very good.
In the US, for example, the US foreign corrupt practices are kind of similar because of the titles.
But would be the criminal side. So
Yeah, from the criminal
and that's why I'm
side.
curious
That's
about the
the-
civil side. You know, and we have seen more cases of civil society groups bringing actions against companies, but first by becoming shareholders of the companies so that they could bring actions against the directors for not properly implementing ESG, and through mechanisms like that. And I'm wondering if this is broadening this so that people who are facing droughts in Africa because of climate change can then go to these companies and say, look,
It potentially can open the door to
Yeah.
substantial.
But there are more and more cases in this direction.
Yeah.
Thank you very much, Vitaly. Now I have the pleasure to introduce you Sven Tja. He's a partner at the Friedrichskraft Fund Westfalen. Correctly, he's a certified specialist in corporate and commercial law. His first IBLC meeting was in Brussels in 2015, and his firm hosted the IBLC meeting in February in 2018.
Thank you. Thank you for having me. And it's a great pleasure seeing so many of you again in person, I have to say. And I hope for all of those watching remotely that we will meet each other again soon. So now, congratulations. You've always almost made it for this professional program. This is the last presentation, and then the fun part will start. I would like to talk to you about a limited aspect of ESG developments, which is a new German law, the so-called Supply Chain Due Diligence Act. I put you also the short version in German on the screen, which is the Lieferketten-Sorgfaltspflichtengesetz. As you may know, we tend to have rather long words in Germany, and it's yeah, kind of a sport inventing. So those long words for the legislators. What are we going to talk about? I will give you a brief introduction into what the law is, what it's about, what is its scope. We will talk about the protected interests that this law is addressing. I will explain to you what the due diligence measures are that this law requires from companies, and I will also give you a brief overview on the measures of control that the government has on the application of this law. So we have already discussed what ESG means, and my colleagues have explained it to you already very well. Of course, it's an important aspect in, as for example, Nicola explained to us, for investment decisions, so that the German government has decided to make an initiative for a law also to implement this aspect further in the German industry, to make it, we can say, with one of the goals to make the industry fit for investments that are focusing on these ESG aspects, but also following the general initiatives of, we have already discussed, the UN or OECD that promote ESG aspects in the industry. And here, of course, as I said, it's the Supply Chain Due Diligence Act. It has a focus on the supply chain of companies. The law is new, as I said. It passed the German Parliament on 11 June last year, and it will be effective from January 1st next year. It will apply from January 1st next year onwards to companies with 3,000 or more employees in Germany. So it's only applicable to larger companies, and other than with the EU directive, as we heard, that also takes into account the turnover of companies. Here, the only aspect for applicability is the number of employees employed in Germany. This threshold of 3,000 employees will be lowered to 1,000 from 2024 onwards. So it's a stepwise approach. First, larger companies are within the scope of this law, and then a year later, also smaller companies, so that these smaller companies are given a bit more time to prepare. Let's have a look at the protected interests under this new law. There are two aspects. There is one human rights, workers' rights aspect, and then there is an ecological, environmental aspect. However, the human rights aspect has a lot more room in this law. So the focus is mostly on human rights, on workers' rights. Of course, we all know that in the worldwide supply chains, there are some, especially in developing countries, there are sometimes very poor working conditions. In Germany, it was a big story when there was a fire in a shop in Bangladesh, and many workers were killed due to the fact that the doors were locked so that workers could not escape, just to force them to stay working. And of course, this is something that is cruel and created a public outrage. And therefore, these aspects are at the core of the new Supply Chain Due Diligence Act. The law works with a catalog of prohibitions. So it does not say what has to be improved, but it says what should be avoided. And that's above all child labor, slavery, forced labor. It's disregard of occupational safety rules. As I mentioned, the fire in the Bangladesh site. It's disregard of freedom of association. So labor unions may not be prohibited within the companies. It is against discrimination against employees for all kinds of aspects. Gender, of course, is one of them. It states that it's prohibited to withhold the minimum wage from employees. Of course, minimum wage here, not meaning the minimum wage that is applicable in Germany. It means wherever the employee works, the national minimum wage. And amongst in the catalog of prohibitions with regard to human rights, there is also a prohibition of destruction of natural resources, land, drinking water, etc. It's not regarded, for whatever reason, I don't know why, as an environmental question, but a human rights question, because access to drinking water, access to a safe pieces of land and is regarded as a human rights aspect. And the law has also a catch-all clause in this regard. So all similar acts that infringe the protected interests are also prohibited. Probably the lawmaker feared having forgotten something in the list, in the catalog. So they introduced this catch-all clause, which of course now is highly discussed in Germany amongst the doctrine. What does it mean? And of course, that's a playground for lawyers, such a catch-all definition. In these prohibitions, in several places, references made to international conventions. There are, of course, these international conventions we have discussed on workers' rights, for example, and that's, of course, for orientation purposes in this respect that these international conventions are mentioned. As I already said, on the other side, there are environmental risks that have to be taken into account. But this is more limited. So the law talks about certain chemicals, and their use and processing. It talks specifically about quicksilver, and its processing and use, and then about hazardous waste, unsafe storage, handling, or import-export. In violation, again, of international conventions is addressed by the law. These are also prohibited activities that have to be avoided within the supply chain. So due diligence means that you have to follow up with certain measures, and this is to be applied. What measures I will tell you in a bit, but first of all, to what does it apply? Where does the company have to apply these rules? To all goods and services of the company. So it's very broad, and throughout all steps of manufacturing of the goods or rendering of the services. And that's very important, throughout the entire worldwide supply chain. So first of all, of course, the company has to watch that these prohibited infringements activities are avoided within its own business, but then also concerning its direct suppliers, and further on concerning its indirect suppliers. So wherever in the supply chain, from the raw materials that are sourced anywhere in the world until the moment when the final product or the final service is rendered to the end customer, these due diligence obligations apply. Which means we have talked about the focus on the large companies that is in this law. So it applies only to companies with 3,000 employees or more. It's, of course, big companies, but these companies have to implement the rules also in their supply chain. So that means their suppliers, their indirect suppliers, are also affected. And that can be, of course, small and medium-sized companies as well. And it can be also non-German companies. It can be companies worldwide that are coming into the focus of these larger German companies, because they are forced to implement the law within their supply chain. So what is required? What requirements does the law pose with regard to the due diligence obligations that the companies in the scope of the law have to implement? First of all, each of these companies has to implement a risk management system. So they have to make a plan to identify risk, to address these risks, to mitigate them, and to avoid them. How to do this, the law does not specifically say. The law says they have to implement such a system, and what the law says is they have to define an internal responsibility. So someone within the company is responsible and has to address these questions. It is a so-called human rights officer, a Menschenrechtsbeauftragter is the German word, that has to be appointed. It is not so clear at what level of the management such person has to be appointed, but it should be a person reporting directly to the decision takers, so to the board of the company. Having identified a responsible person, a risk analysis has to be conducted. So companies have to evaluate where there are risks within their supply chain, that these prohibited activities are conducted, or that these environmental risks appear. And this analysis is then the basis, of course, for all the measures that have to be taken. The risk analysis is also the basis for a declaration of principles, Grundsatzerklärung, the German term, that the management has to make. And the management in this declaration has to address, has to say what risk they have identified and what they are going to do against, and what their measures will be. And this is a public declaration that has to be published on the website of the company, and it sets, so to speak, and that's the goal of the lawmaker, it sets the tone from the top. When having identified any risk, preventive measures must be taken. So the sourcing strategies of the company have to be implemented in a way to avoid the risks. Training has to be provided to employees to identify and mitigate risks. And what is an important tool, at least in our practice, there has to be a code of conduct that gives guidelines to the employees how to address the risks, how to avoid them. Of course, this can be also implemented in the contractual frameworks along the supply chain. So if you have contracts with your suppliers, you put in clauses obliging the suppliers to observe the human rights aspects, to avoid all these prohibited activities, and of course the environmental, the non-compliance with these environmental obligations. If there is a violation detected during the risk analysis, or whenever during the entire year, or when the company is active, remedial action has to be taken. Also here, of course, the law is not specific, does not say what exactly has to be done. Of course, it depends on the situation. Usually the supplier where the risk has been identified has to be contacted. A plan has to be laid out to mitigate or avoid the risk for the future. And it could be, as a final consequence, if all that is not possible, that a contractual relationship, a supply relationship, has even to be interrupted, suspended, or to be ended entirely. But that's only the ultima ratio for such a situation. Further, and as a last obligation of due diligence, the risk analysis and all the measures that are taken have to be documented regularly, on a regular basis, and at least once a year a report has to be set up and has to be published on the website of the company at the latest 4 months after the closing of the financial year. And such report must remain published for at least 7 years on the website, so that everybody can inform himself, herself on what is done in the ESG sector in this company, which may be an interesting source for funds and for others of information on the ESG compliance of the respective company. The due diligence that the law asks from the company has to be a reasonable due diligence. There is no direct duty to achieve any results, so it's more a best efforts obligation that the companies have to conduct. Probably that is one consequence of heavy lobbying that has been going on throughout the legislation process in Germany. There is one exception. If there is a breach identified or risk identified within the company's own operation, then there is a duty to resolve that. That's not only best efforts. It's really a duty to have a certain result to avoid the risk for the future. The reasonable due diligence, it's determined in accordance with there are certain aspects, as I have listed on the slide, the nature and extent of business activity. So what is the company doing, the potential influence of the company on the respective risks. So how close is the company to that risk? It's a direct supplier, indirect supplier, of course, makes a difference. The typically expected seriousness, the reversibility of the risk, and also probability of violation have to be taken into account, and the nature of contribution of the company itself to the cause of the risk. So this is a catalog of aspects that have to be taken into account to identify what are the reasonable measures that the company has to take. Finally, I would like to give you a brief overview on the mechanism of control that is implemented on this law. It's an administrative law, so there is an administrative control. There is an authority, a German federal authority, a Federal Bureau of Economic Affairs and Export Control, that is in charge of controlling this. And they can summon persons, they can do audits on the companies. They can make the requests to provide a plan with remedial actions if there are violations detected. And they can even issue orders, direct orders to the companies how to fulfill their duties. If the company does not comply, penalties can be applied, penalties of up to 50,000 euro, which is a measure of enforcement. So penalty is applied until the company finally follows the orders, or fines. So administrative fines can be administered to those companies not in compliance, from 100 to 500 to 800,000 euro, depending on the violation. Or for very large companies with annual turnover of more than 400 million euros, it can be up to 2% of the annual turnover of the company, which is of course a significant amount of money. Also, a consequence of companies violating their duties could be that they are excluded from public tenders, which is also to certain companies at least a very harmful consequence. So that's briefly the German Supply Chain Due Diligence Act. As I said at the beginning, it will be in force from 1st January next year. And of course, I'm happy to answer any questions that you may have.
What are your recommendations for companies outside the current scope of the Supply Chain Act?
Mm-hmm. Yeah, as I said, I mean, it's applicable, of course, to large companies with more than 3,000 employees in Germany. However, as these companies have to address their direct or indirect suppliers, it affects also smaller companies. And my recommendation is that they should really take action and not to wait, and to address these topics, to draft a code of conduct if they have not yet done so. Because what we see with our mid-sized clients, for example, in the automotive business, there are large players like Volkswagen and so on, and they send question letters to their suppliers where they have to tick boxes. Do you have a code of conduct? Yes or no? And if you tick no at this stage, you're already in trouble, because then they will ask further questions, and in the end, of course, you can risk losing the relationship with a big, important customer. So my recommendation is to take action, even if you're not within the scope of this law.
And another question, can you give an example of how a company can conduct a risk analysis?
Yeah. So we have done this with one of my clients recently, also a company that is not directly in the scope of the law. They have not so many employees in Germany, but they are suppliers to big companies. And what have they done? They have, first of all, made a list of all suppliers they have. And they were surprised how many these are. They have taken this from their SAP system and all the addresses. And then they have made groups. So they have taken all suppliers that are within Germany and said, well, probably it's a low risk that they will have slaves or child labor in issues. So they have put them on one side. They have taken all the suppliers from within the EU and have looked at them and said, well, this is also low risk. And then in the end, to their own surprise, there remained only 3 suppliers outside Europe, one in Vietnam and other 2, I think, also in Asia. And then they have looked at these and have looked at what do they supply to them, and have started the risk analysis from this point. So in the end, it was not so big an issue because 99% of their suppliers were within Europe, where you can expect that by the law that is already applicable, people get minimum wages, people don't have to work under conditions that are to be defined as slave worker workshop.
Okay. Thank you very much, then.
Thank you. Yeah, of course.
Are there any aspects of private enforcement that any impact on direct liability?
So private aspect yes, there's an indirect private consequence also because the companies have to implement these aspects in their supply chain, and as a preventive measure, they have to, or they should at least, in their contract with suppliers, they should provide for clauses obliging the suppliers to comply with these aspects. So of course, then if a supplier does not comply, this is a breach of contract, which can lead to civil liability. And then also for the directors and officers, there can be a liability because if they do not implement any risk management system, and then the company is imposed, a fine is imposed on the company by the authority, of course, that's a loss for the company that was caused by the misbehavior, the non-compliance of this management, of the manager, which can then, for example, in a GmbH, the manager can be personally liable to compensate for this respective loss to the company.
Is there any prospect for an EU directive or regulation that would require similar things in all member states?
Yeah, but I mean, that's what Ricardo has explained. So this is the EU perspective. And here, strange enough, Germany was a bit in advance. Normally we are behind when implementing EU directives. But that's the way it's going to be. So the directive is applicable in all the EU.
So this would be seen as implementing the directive that Ricardo is
talking about? Partly. So not all, as I said, there is a focus more on human rights, workers' rights here. Probably the German law will have to be amended going forward to cope with all the aspects and all the requirements of the EU legislation.
And criminal or administrative law enforcement as opposed to civil law enforcement. So which makes it a very different animal.
Yes. Yeah, it's a different starting point. I mean, the goal is the same, at least for the aspects that are covered. But yeah, it's an administrative law in Germany.
Interesting.
Still a lot of development that is, I think, going to happen.
Do they have a short version of the title, like Gesetz or something like that?
Yeah, LKG.
Okay, that's really short.
Yeah.
LKG.
Yeah, I think it's
Or
LKG.
Okay.
Yeah.
And I think it's like 11 o'clock tonight. You have time.
Yeah. But what I wrote on the first page is only, this is only the short form of the name of the law. So there is also a long official name, but I will not tell you.
Good. I'm sure we have lots of questions that you can ask at dinner and about other things. And it's not long, it was just ask the bus or there was one.
Thank you.